I'm a small firm, kind of boutique litigation attorney here in New Orleans, Louisiana. I wouldn't say my practice focuses on flooding, but flooding cases have sort of found me. And I think as this just today's forum and hearing all you speak, I think it's quite obvious that this is a huge issue, and there's a need, and everybody's grappling with what they can and cannot do. That what my firm has tried to do, and we've been pulled in along the way, is when people have been in need of after the flood. And I know a lot of you guys are focusing on that, but your focus is looking forward, and I will try and touch upon some of that as well. So again, I wouldn't hold myself out as more of an expert in flooding, but I've been involved in some flooding cases, and it started back. I don't know if y'all can see that.
There you go.
All right, so if everybody can, I've put up a screen where kind of the flooding cases found me after Hurricane Katrina, and then that led to what a lot of you may have, and it's not really today's talk, but I can speak to it. I've given some presentations on it before, which is flood insurance claims. But again, I didn't think that was what you all were looking for today. I was going to kind of give you my perspective of what I've seen, but this flooding can often lead to flood insurance claims, and that is a whole area of litigation to its own. And I'm one of 2 lawyers in New Orleans that actually took a flood insurance claim all the way to trial at the United States District Court of Eastern District of Louisiana. It's hard to believe only 3 cases did go to trial after Katrina for flood insurance, but there's reasons for that. The system's not really set up to encourage lawsuits or to be an incentive to make it worth your while to go. I was also involved in what you guys will see as shorthand, and those of you who live in Louisiana will be familiar with the term of Mr. Go. That's the Mississippi River Gulf Outlet, where the city tried to hold the Corps of Engineers accountable, not only for the levees and the flood levees around the city, but also an economic channel for shipping. And I'm going to go into more of this later. Then fast forward to recently, the town of Robert, Louisiana, had a major flood in 1983 caused by a highway, Interstate 12, that went right across a floodplain with 3 tiny openings, even though it was a mile-wide floodplain that, when left to nature, it basically should carry the amount of water the Mississippi River carries at the it's the same depth and same width at the same latitude of the Mississippi River, and now there's a highway with 3 small culverts that let the water go through. There was litigation that I was not involved with in the 80s, but then it flooded twice again in 2016, and we've had several forays into that that I will go into and kind of tell you what we've had specific to Louisiana, but where I think there may be some ability for these groups to look at going forward. Unfortunately, several have been very unsuccessful. That leads us to the Hurricane Harvey. I've got some good friends in Houston who flooded after the release of the reservoirs. That has made the news and is a pretty big case going on in the Federal Court of Claims. I was one of the first lawyers, just on behalf of a friend. Everybody was saying they couldn't file a lawsuit, and one of my friends is a lawyer there, and I told them, we could absolutely file a lawsuit against the Corps, because this wasn't, even though it was flood control, this was a specific action by the government, and it's called the takings claim, which then leads me to an active case that I'm involved with. It just brings me to this forum, which is the town of Richwood versus City of Lake Jackson, and Kevin's on board on this call as well. And so that case ties in several of these things, these ideas of, can you sue the government or a government entity? So next up is, the way we get involved, or as my friends and colleagues get involved, is often people flood and they say, what's next? What I said earlier is the most typical type of things that lawyers will see is the insurance claim, flood insurance and homeowner insurance. And those are 2 very specific things. And again, I'm going to save that for later. If you guys want to get into that, I'll be happy to. But the flood insurance program in some way works well, but from a litigation standpoint and for people who are not properly made whole by the insurance, it's an exceedingly frustrating and probably unsatisfactory result. So what you often can see in flooding cases, and I don't think this is the case for everybody else, is if your neighbor floods you, you often can you have a remedy. And I think that's kind of what I'm hearing from this forum is everybody's trying to figure out what can we do. When it's your neighbor, you have an idea. You can sue him. You can get an injunction against him or her. They build a wall they're not supposed to. Most states have ideas in real estate that you can't channel water to your neighbor to where they bear a burden more than you have a burden, or change the natural drainage. But what happens when, and this picture will be familiar to Kevin, when the flooding just didn't happen and it wasn't just your neighbor? What do you do? The question becomes, can we sue? Who can we sue, and then why sue? What are you going to ultimately get out of it? Traditionally, with flood, any type of lawsuit, we get lawyers. Often we can't make people do anything. Courts don't like specific performance. So often it's about the money. But there are some avenues to look for. I'm getting some feedback. I don't know if you guys are hearing that.
I'm sorry, this is Earl.
All right, it's quiet on my end. Can you guys hear me? Because it was, okay, I'm seeing nodding heads. Okay, great. So I think this is, again, this is the question. Can we sue, and who can we sue? And what happens when it's a governmental entity? It's a little tricky because one of the initial doctrines is governments often have what's called sovereign immunity. You can't sue them unless they say you can sue them. Thankfully, we actually live in a country where state laws and constitutions give us some actions where the government has said you can sue us. And the two ways we generally see that, and I'm going to kind of talk about the second one first on this list, is the federal government and state courts often have something which is called a Tort Claims Act. And that's just like if somebody were to hit you in a car, you can go and say they did something unreasonable and they were at fault. And it is, governments say you can do it, but there's a lot of hurdles and hoops to jump through. You often have to give them a specific notice on a specific form, and you have to explain, that you fit within the law that they said you can sue us if A, B, and C. And so you have to be very specific and say, we fit your program for when we can sue you. It's a bit loaded. You're going to a state court to sue the state, or you're going to the federal court to sue the federal government, but it's the best we have. The Federal Tort Claims Act was used, or attempted to be used, here in Florida after Hurricane Katrina. And unfortunately, what we learned down here in New Orleans is that this is not a great piece of legal or great legal tool to attack the flood issues. What most people knew and what we learned and was reasserted was any type of flood work, especially by the Corps, it's immunity, period. So if they mess up, as long as they were trying to stop flooding, they get a free pass. And then, so the lawyers down here had an idea, well, let's go after the projects that the Corps does that isn't for flooding. And the district judge agreed that Mr. specifically, the outlet, was an economic development outlet. And so if they did build it unreasonably or maintain it unreasonably, you should be able to sue them and get your damages. Unfortunately, the U.S. Fifth Circuit flipped that on its head and basically said they have immunity for any type of discretionary function. And so the way I review the law, and again, other lawyers may have a different view of it, I don't see a good example out there where flood cases survive under the Federal Tort Claims Act. And so that's unfortunately, to me, that's not where I look anymore when people come to me with these flooding claims against the government. I think a much better area to sue them on is under the U.S. Constitution's Fifth Amendment. and this is what many of us have heard as what's called a takings claim or an inverse condemnation claim. What you generally need in this is you're not proving fault. You're gonna state that a government, whether when you're suing the federal government took an action, and it's not inaction. It has to be they took an action that took your property. You're not saying they couldn't do it. You weren't saying they were at fault or they did it unreasonably. You're just saying under the Constitution, when somebody takes your property, whether that's your physical, immovable property, or whether it's your belongings and personal property, they owe you money, because that's what the Constitution says. The government can't come and take your property. And I think this is a ripe area when you have a specific government action to go forward on. And this is what's going on in Houston right now. It's probably the case right now in the country that's getting the most news. There's a group of lawyers, and I'm only very small part involved. So I don't want to take any real ownership on it now. I got involved very early to make sure it was going in the right direction, and now there's hundreds of lawyers on it, and my role is very much diminished. But essentially what has happened in Houston is after the Hurricane Harvey went through, there were two reservoirs that were getting close, at least the Corps thought were close to breaking and flooding. And so they decided that they were going to open up the floodgates and release the water. And they knew it was going to affect homes, and it was going to flood people. And so the cause of action against the Corps of Engineers, in the Court of Claims against the U.S. government is, you made a decision to flood my property. So you took my property for the benefit of the public and for other property. And you can do that, but if you're going to do it, you owe me my money. And there's some other nuances to that case for the people who were behind the reservoirs, but I'll get into that more if you all are interested later. But essentially, that is an active case right now against the federal government for doing that. And so that's, again, in the news. So when you read the Houston cases, I think that's worth listening to and keeping your antenna up. Like I said, a takings case against the United States, which would be the Corps of Engineers or the Department of Interior. You can even sue the post office. There's a pretty useful case out there where they built a post office, and because of the way they built it and the parking lot, it created a flooding issue, and they sued the federal government on a takings claim, saying the flooding was causing a takings. Many of these claims you have to file at the court in D.C. called the Federal Court of Claims. It's a separate courthouse. It's actually just east of the White House, one street over. And this is one of the main functions they have is to hear takings claims within it. Its court, you get 6 years to file, so it's a pretty liberal time period to determine, if you flooded or if anything was taken. Doesn't have to be a flood. The problem with this is it's only good against the federal government. You can't sue a state in this court. If you were going to sue a state, you'd have to go to your own state courts. Now, the good news is most state constitutions mirror the U.S. Constitution, and whether it may not be specifically in the Fifth Amendment, but most state constitutions that at least I've talked to other lawyers about, I haven't looked at them all, is they have a takings clause where they say the state shouldn't be able to do that. And often states have tort claim acts. And again, if you'll remember back to my earlier part of my discussion, the Tort Claim Act, you basically have to fit their program or their diagram where they say you can sue us if A, B, and C happen. So those are very state specific, but also that there's a takings clause in most state constitutions. Again, you got to sue the state in its own court. But from what I've seen, that hasn't been terribly troublesome. The courts seem to get it, and actually some of the judges find it very interesting, and I would say they think it's very important for the people to have a forum to go to on a takings claim. So that, to me, that's where I think there's ripe action. When you can show that the government took an action and that is causing your flooding, there's documentation, there's case law out there now that it doesn't have to be a permanent flood. That used to be the case a long time ago. Like if the government built a dam, the only people who could sue were the people who were permanently flooded. There's been a change over the past 40 years where courts have recognized that Intermittent flooding can be a taking, and even a one flood from a government action can be a taking. So those are, to me, those are looking back, retrospectively. If I've been flooded, what can I do? I do think there's also an area of the law that may be looked at is if you want to try and prevent future flooding, is maybe get an injunction. In my cartoons I'm showing my age of the Schoolhouse Rock, conjunction junction, always jumps to my head when people start saying injunction multiple times. So this is generally permitted under state. You'd have to be permitted under state law, but most states do have some type of injunction. Some can be temporary or immediate, and others can be more long-term. Generally, to get an injunction, the general rule you'll hear is that you need to be harmed in a way that's beyond just money. If money can fix you, a lot of times courts don't want to get into it. But that being said, a lot of state statutes will specifically say that you can get the government or somebody to stop acting if they're doing something in real estate, and like the serving estates I was talking about early falls into that. I think this is an area of law that can and should be developed more in Louisiana and probably in other states. So kind of to get back to where I started was, well, how did I come to these flood cases, and where have I seen some success that maybe you all can look at as an example, or when you're talking to lawyers in your areas of where you may want to explore, do we have a cause of action? The insurance claims are, it doesn't solve the flooding, but it does give people a remedy and relief. Those are strong, usually against your homeowner's insurance. They're not as good on flood. And again, I won't go into that right now, but the short of that is it's administered by the federal government, and the carriers basically are a middleman. And so they'll pay what they pay, and then they don't, there's no remedy if they don't pay you. If you go to court and win, you only get what they owed you. And you still have to pay a lawyer, and you still have to pay court costs. There's no sanction. So the better claims and insurance claims are against the homeowners policies. And in some states like Texas, there's significant penalties, which also helps keep them more in line. In Louisiana, unfortunately, there are not good penalties. In the town of Robert, Louisiana, there was a very successful case, and I'll put successful in quotes, against the state for over $100 million. And it was based upon a state law specifically as to drainage. And I was talking to you guys earlier, a lot of states have rules that one person can't burden another with their drainage. Well, that went forward. There was a $100 million verdict, which in most cases you'd always say is successful. The problem in Louisiana is you cannot force the state of Louisiana to pay. So there is a 1996 judgment that now with interest is probably close to $300 million that is yet to be paid for the residents of Robert, Louisiana. In the Robert, Louisiana, the Federal Tort Claims Act was tried, and the federal courts threw that one out. There is a federal takings case that is now we're waiting for a ruling from the court. Even though the bridge was built in the 60s, we've made an argument that we're within the 6-year statute of limitations because the floods, there's been 3 floods, 1983 and 2 in 2016. And the government's position is you need more than one flood. So we're going to in our case, we said we're going to take the government at their word, and we now have more than one flood. And that's why we're within the statute. We also have a state takings clause that in Louisiana, specific to our statutes, the district court said we should be able to go forward, but the district court said we could not, and the state Supreme Court wouldn't weigh in. So our state takings claim has gone by the wayside, but we still have a state injunction claim against the state we're trying to get them to remove the highway, or at least put more culverts underneath it rather than 3. So that's still, so some of those avenues have been foreclosed and some are still open. We talked about the Hurricane Harvey. The federal takings case is moving at quite a fast pace. It was filed at least 6-8 months after my town of Robert takings case, and they are probably they're, I'd say in the case, they're already a third of the way through, where in our case, we're probably only an eighth of the way through. And that's because the court has recognized, I guess, that more people were affected, and they've kind of put it on a rocket docket. And then coming to Kevin's case, the town of Richwood, we have asserted a state takings claim. And there's a little quirk here I want to add about the town of Richmond. This isn't against the state. Here we have a community that is suing a neighboring city that put up a temporary dam and temporary pumps to protect their property, to flood out the neighboring residents and neighboring town. So we have filed a state takings claim against that city, saying they took an action, and if they had the right to do it, they owe us the money. We've also sued them under their state Texas Tort Claims Act, saying they did things that fulfill the ABC requirements, and so they owe us just for our damages like a tort. And then we have possibly an injunction, and that's sort of how we found this forum, and we found Harriet, is this community could probably use some help in setting up a plan of how do we show the court system that we want to stop this from happening again, especially when we know the neighboring town fully intends to do the same thing the next time there's a heavy rain. I think I've run through that pretty quickly and probably exceeded my time. So that brings me to the end of my presentation. But I'm happy to take some questions, and if I can't answer them now, I'll do my best to answer them later, or maybe you guys say, fill us in somewhere else, and if I have a little, you need something beyond my perspective, I can do some research.
Wonderful. Thank you so much, Eric. That was really fantastic. I really appreciate it. I wonder if you could stop sharing the screen, and then I can easily open everything up so that I can see everyone and manage questions. I thought, Kevin, it would be wonderful if you and, Eric, stop him if he says anything that's sensitive. But Eric, so Kevin, from your perspective, it would be wonderful if you could just talk just for a couple of minutes about what it feels like leading a group that's in a lawsuit.
Well, I've never done it before. And the neat thing about this is the cooperation that we're getting from everybody in the 450 people we have down here. We have, the one thing I want to say about our group is that we have eyes and ears on the ground at all times. And Eric knows that. And we send information to those guys on a constant basis, because you saw those pumps in that one picture hooked up to that drainage, and that came right into our neighborhood. And, we want that to stop. And they're playing around again in that same area right now as we speak, because they know that we got a tropical depression coming at us, and we got Hurricane Ike right behind that getting ready. I'm looking at Hurricane Ike real closely, because our ground is saturated so much right now that with this stuff coming in off the coast, it's we're liable to have some pretty serious flooding. Well, those guys are out there testing that stuff again, and I've got all those attorneys on standby in case they do want to start that again, to possibly get an injunction to get it stopped. So it takes everybody's cooperation to move forward and to make a difference. And I think that's the neatest thing about what's going on down here is the eyes and ears on the ground, everybody playing a part and trying to stop what's going on and to make it better down here. So, with Eric's help, we're moving forward. They haven't turned us down yet, and we're in this to win it, okay? We got the guys on our team to do it for us. So, my hat's off to Eric and his team and who we've got, because you know what? They haven't thrown this out of court yet, and we're still plugging ahead. So, my hat's off to the people that I'm surrounded with, Miss Harriet. Those are the successful people. We're all in this together as a team, and that's what makes it. That's what I'm getting out of it. And to meet all these people and to work hand in hand with these people, yeah, I'm in. I'm all the way in.
Wonderful, thank you. So I've got a few people who lined up to ask questions. But before we do that, I would just like to quickly ask Denise. Denise, are you still there? You just temporarily got off the screen. Denise? I'm going to unmute you. I'm going to try and unmute you. Wonderful. Denise, you are in an unusual situation whereby you're involved in the Lemon Valley Advocacy Group, but you also have, you know, another person who's kind of, you work with, who's involved in a lawsuit. And that's a sort of, and you know, so you're slightly split. Could you just tell people about that? Because I think it's an interesting approach.
Well, we have a class, well, we don't, I'm part of our membership. They do have a class action lawsuit going on. The county has kind of blackballed those folks from talking to them and helping them any further with flood issues, or even so far as not issuing permits for them to do repairs to their home. It's been a wild ride. Right now we've been trying to fight the county, stop them from allowing more building to go on because we have no room in the sewer treatment plants, nowhere for that to go, and yet they're making rulings to allow more building to come into our area so that those developers can pay, supposedly, to help repair the infrastructure that the county and the city have done to create this flood issue. And so we have the lawsuit against, it was a class action lawsuit against the city and the county, and for some reason the judge went in and released the county from the lawsuit, and now there's that lawsuit with the city. But right now the county is taking actions that it's going to cause another flood without a doubt, and at that point I guess we'll have to go after them. You know, was there something specific that you had in mind, Harriet?
Yes, that's wonderful. Thank you. So Suzanne, you had a question.
I had a couple of questions for Eric. Eric, I'm hoping you can give me the sentence that I want to use at City Council tonight. They want to build a police station that for numerous reasons is a bad thing, and it's going to cause flooding where they're building it. So I would like to say what you said, that if anything is built by the city which causes damage to properties due to flooding, that makes the city vulnerable to a takings claim lawsuit. Is that right in New Jersey?
Oh, unmute. Sorry, you seem to have gone on mute.
Who?
All right, I was me.
Oh.
All right, I mean, it most likely is right. I'm assuming New Jersey has a takings clause in its constitution. And if it does, any government action would make them potentially vulnerable, as you said, for damages if their action created damage, regardless of if they thought it was useful or necessary. Again, it's not a lawsuit that places blame or fault. It's basically saying if you take action as a government as a public purpose and it takes people's property through flood or otherwise, they are vulnerable. So I think, you know, as long as the New Jersey Constitution says that, which you could probably bluff your way through. I'd be surprised if it didn't. I do think there's a possibility, and then there's a possibility that there are other forms of action. Like I said, in Louisiana, we have specific rules in our civil code, which is everybody thinks is so different. It's not that different. It's what everybody else refers to as just basically their state code. And we have very specific rules about you can't flood another estate. And that's sort of what this sounds like. You're worried about they're going to build a parking lot or a wall or a ditch or a culvert.
A police station.
Yeah, but it's going to have something that's going to cause runoff.
Absolutely.
And so that is, you know, that they are potentially vulnerable too on that. But I mean, I think as long as New Jersey has a takings clause, and you could probably Google that pretty quickly, that I think you could say that, you know, it's your understanding that if they're going to do that, this community knows they have a right to proceed under the state constitution to get compensated. And why would they do that? Why would, you know, wouldn't it be better to do it right and not be subject to a compensable claim later?
Oh, that's a good one. Also, is there any group of lawyers that works pro bono for groups like mine that would come up and say that to our council?
I don't know. I don't
to ask about lawyers, but
yeah, I don't know about that. I mean, that's again, that's sort of how I've gotten pulled into a lot of these cases. There's a great need for it, and I don't think there's a great stock of lawyers that have knowledge on it, because the rules and laws are so different. And then, you know, it's also to find, you know, you either have to find a lawyer that is can do it for free, or you've got to find a way to get paid within the statutes. And that's not always there. I know in Louisiana that's extremely difficult. We have very few laws that allow for attorney fees, and so that makes it hard as well. So short answer is I don't know of anybody, and I don't even know where to point you to look for that. I'll have to put my thinking cap on you know, where it might be a place to explore it. The one place you might be able to, and I don't know if this would be soon enough for you, but I do know that big firms, I practiced in Virginia for a while, and I was with a giant firm that had New York offices and Richmond offices. We numbered in the over, I think, 1,000 lawyers. They often want young lawyers to get opportunities to be publicly active as a lawyer, not really for the notoriety, but for the experience of presenting an argument. And there may be something there to see if you could get, you know, they'd be younger, but they would be probably very engaged as long as they didn't have a conflict or a potential business conflict later. Again, I think that's more of a long-term project to identify those lawyers, but I know they're desperate. These young lawyers are desperate because very few things get in front of courts and committees that they're desperate to get that experience and not just be a library lawyer.
how do I find those kids? Because I'm all right with young kids.
Right. I think well, a couple places. There's probably some pro bono programs there. I don't know if you have one. I know here we have one called the Pro Bono Project. So if you and the other places, and it may not be an exact fit, but if you called like maybe one of the directors, there's generally most places have. I'm trying to think what they're called. They're more for lower income, working income people. There's pro bono projects, like legal aid societies. You may want to talk to one of those directors, but I wouldn't be surprised if there may be something that actually is called something like a pro bono project somewhere in the state of New Jersey, especially as you get closer to Manhattan, that there's probably a director, and you could explore with them how they find their volunteers. And so I don't want that. I could talk to you, but I don't want to take up too much time on it. Again, that would be a long-term project, but I bet there's some lawyers out there, and you're actually going to get, in some ways, a better one if they're younger and they're hungry and they want to make a name for themselves.
Thank you. So
Thank you.
got lots of people asking questions. Let's go to Gabriella, who has a question. Gabriella, are you there?
Yes. Yeah. Can you hear me?
Yes.
Okay, great. I was wondering, the comment you made, Eric, about the two levies, one being released to relieve some of the pressure. What was the basis of the decision on which levy to open? Because I represent an environmental justice community, and we have a lot of things like that, you know, that our decisions are made to dump on the environmental justice community. So I was just wondering, on what basis was it made?
I don't know exactly. I mean, they're right in the heart of taking those depositions of the Corps of Engineers to find out who made those decisions and why they made it. My understanding is they made it, and they made it publicly in the Houston one because they knew it was going to be catastrophic with the release, and they didn't want to risk lives when they released it. in Houston, probably what's different from yours is the release actually hit a upper middle class to wealthy class of residents got hit. It wasn't. I don't think it was a decision basically to save some people's houses and purposely do the others. It was a decision, and I now, with hindsight, I know they're questioning whether how was it the right one? Was the dam gonna really break? So I don't have a good answer to that, and I think they're learning that. But it was decided. I mean, there were people in Houston that made the call. We're gonna release, and they actually had models pre-storm. If we release, here's who we expect to flood. And interesting in the lawsuit we've learned is also they didn't tell people behind the dams that they were within the retainment ponds. They never even paid, usually there's like some type of easement the government had paid for 50, 100 years ago in the background. Their own models of they knew they were going to be retaining water 5, 10, 20 feet above people's houses.
Wow. We have something like that here. We're fighting the development of a wetland. It's a 30-acre wetland, and they're taking 18 acres for a strip mall, basically, hard surfaces. On the east side, we have a high risk, but on the west side, they're closer to Arthur Kill, the body of water between New York and New Jersey, and they were flooded before, and it's a mobile home park, and they're going to be flooded again.
Yeah.
So.
Yeah, one of the problems with taking claims is they're retrospective, right? You've got to flood to get your claim, and that's unfortunate. I haven't figured out how to prospectively use it.
Yeah, that's unfortunate because the people in that mobile home park are elderly and disabled.
Wonderful, thank you. So, Laura,
Thank you.
you had a question.
Me?
Yes, I think you had a question. Is that correct? You put one on chat?
Yes, I do. Yes. Thank you very much for the information. We're faced right now in the tan yard. The city just keeps telling us, it floods. Well, every time it rains, not only does it flood, we have thousands upon thousands of gallons of sewer that comes up. And they don't vacuum it up, they just let it go down into our stormwater. Now, there's property across the street, it's 19 acres, that they want to make a field house and make a sporting event. They want to raise the property 12 feet. That'll be higher than my house.
Oops.
I lost you. I'm back.
Yeah, you're back.
Yeah, I'm back. So looking at this, what did you call it now? I wrote it down, now I can't find it. Since I know the property floods already, and now our property floods already, the street floods, everything floods around us. Now they're talking about building 19 acres across the street from us and building it up 12 feet. Well, that's going to just put us in a big, worse condition. They're not going to prevent future flooding. So I'm just wondering, in Florida, what's the best way? Is taking cause might be a way of utilizing it, or fighting this, or getting some relief?
Yeah, I'm not sure. The short answer is I'm not sure. I mean, that would be Florida specific. I'm a little hesitant to say a takings clause is the way to go, in the sense that there has been, I've seen cases out there where the courts don't want to use a taking clause when it's just permitting and zoning, because that's not the action. So maybe from a litigation standpoint, it's who's doing it. And again, that's here you have the government. So I'm assuming it's the government doing that action. So I guess potentially after the flood, you might have one to, you have to link up causation, that action caused this flooding. That's one of the difficulties that we're going to face in that Richwood case. Is one of the defenses is going to be Well, it was a century storm, Hurricane Harvey. No matter what happened, they were going to flood anyway. So takings clauses are retrospective, and they don't. The stuff I've seen is they don't like to apply it to permitting. So I guess you'd have to be creative and see if you could do it somehow, saying it was the actual building of the structure and not specific to the zoning or permitting.
Okay, but we're already flooding.
Right.
That's one of the issues. We're already flooding. And this would be a public-private endeavor.
Yeah, I think, again, takings would be retrospective, so you would have to flood and then file and say that that building caused it, and you'd have to have some hydrologist to link it up to say, yeah, that was caused by that. They weren't going to just flood anyway. So it's I don't think it's a great fit. It's it's a bit of a square peg for that hole from a takings. It's and that's one thing that I haven't been involved with. But maybe that's more of the idea of an injunction, which I don't even know if you can do that with permitting and zoning there. So maybe you need a lawyer that's a permitting and zoning lawyer, and somehow you got to navigate the county or city structure, which can be maddening. And maybe I don't know how successful that is if you don't have a receptive counsel.
Okay, thank you.
So I'm afraid we are running out of time. Laura and yes, Tracy, you had a question.
I'll try to ask the question quickly. In Texas, large commercial or residential developments,
Sorry, we've got a question with Laura and Tracy right now.
Sorry, go ahead.
Oh, you're muted. You're muted.
Oh, I'm muted?
No, Laura and Tracy are.
Oh, Laura is muted. Please, Laura, go ahead.
Okay, can you hear me now?
Yes.
Okay, great. In St. Johns County, in St. Augustine, Florida, there has been a lot of dredging in our bay. And we are a small community that is east of St. Augustine. And we've had a lot of flooding. What we're understanding is a lot of the dredging that has happened in the bay was to bring sand to St. Augustine Beach, which is south of us. And there has been a lot of conversation about how we believe that has added to our erosion and our flooding where we are now in the north of where they took the sand to. And so I'm wondering if that can be a situation where they have done something negative, what is the word for it, that impacts, that affects our property.
Do a takings claim.
The takings claim, where because they dredged, we have flooded. Even though, I mean, right now there's no direct one-to-one proof that that dredging directly caused our flooding.
Right. Well, that's a big hurdle. You do have to have causation, not just a sense that it did. So on any type of claim, whether it's a tort claim or a takings claim. But one idea that just popped into my head when you told me that is, sometimes you can go after the dredgers, and they have insurance policies and they have money. So if you can make the link, that may be a way. I shouldn't say I know, my memory serves me correctly. I think the dredgers of the Mr. Go put up, it ended up being minuscule. We had billions of dollar damages because of the Mississippi River Gulf outlet. But my understanding is I think the dredgers put up put up all their value of all their insurance, which was 25 million for their actions that contributed to the flooding. But I do think on any of these cases, if you're gonna go before a court, you've got to have the link, and it has to be a link of more likely than not. And the way the courts usually, if any of you all have sat on a jury panel, it's the 51% or 58% in a feather. You've got to have some valid scientific view usually through an expert when it gets to be an issue like this, that issue was caused by that action.
Now, when
Otherwise, it's a struggle, and it's unfortunate because the courts are, and the science often doesn't catch up, right? The science may figure this out 10 or 15 years from now, and that doesn't help you.
When you say dredgers, are the dredgers the people that are employed by the federal government through the board of the Corps of Engineers, the actual company that was employed?
Yeah, often often it can be the and now there's often exceptions and defenses to that, but those companies can often get pulled in to it, especially if they knew what their actions were doing or they did something improperly. And so I know not an exact one-to-one, but there's issues where they've been building some canals in New Orleans where they've been successful at suing a local entity. And I think they were unsuccessful on the people doing it because they got out on an exception. But there's often those people doing the activity, if they did something wrong or not per spec, or if they said they weren't going to cause certain vibrations or they're only going to excavate so much and they did more. And then, sometimes you can also then sort of be pulling on the same side of the rope as even the governmental entity because they would say, we wanted them to do it right. They just didn't. But there's a lot of detective work behind that.
Thank you.
So thank you very much. I'm afraid we are going to have to stop now because I want to leave a little bit of a time for us to discuss other issues. Eric, we have literally loads of people who still want to ask questions. I'm conscious of your time and everything. You don't have a junior staff person who you want to train on anything of this that we could field some additional questions to, or what are your thoughts? Is there anything else that we can do to get some of these questions answered?
Well, I mean, I'm happy to try and set up a time, or if there's a way to email them. And I mean, it may be I'm happy to talk to some people, and I can't promise hours of research, but I can give off the cuff. Email can work. I should have put that up on the screen. I don't think that was on any of my slides. That wasn't intentional.
So how would you prefer that to be managed? Would you prefer would you prefer them to reach out to you individually? Would you prefer them to email? I could bunch together an email, or us to set up another time. What would be best for you?
I think let's try email, and if it's because but maybe maybe it's good for the group to hear everybody's, but it sounds like a lot of people's are very individual, and so maybe it's an email, and then maybe it's a phone call, and again, I mean, it's all just as long as everybody knows it's all off the cuff. It's not a lawyer relationship. But just kind of a session to bounce ideas off one another and maybe point you in the right direction.
So you're okay with me sending people your email address for them to reach out to you individually?
Yes,
Wonderful.
Sure, no problem.
So thank you so much. We truly appreciate it. And do stay on if you're interested, or, feel free to leave as well. We've really, really found that information incredibly valuable.
Okay, well, I hope it was useful.
It was incredibly helpful. Yes.
Okay,
really,
great.
really appreciate it.
My pleasure.